information.
Judge Bradley-Baskin, we need to discuss the Guardian Associates ward accounts. I'm not sure what you're referring to.
Those were all legitimate legal fees for representation in probate matters.
The woman you're looking at is Andrea Bradley-Baskin, a sitting Michigan District Court judge. She's about to feel the full weight of federal conspiracy, money laundering, and wire fraud charges. And every count traces back to the people she was sworn to protect.
Nearly $100,000 embezzled from incapacitated wards who couldn't contest what you were doing with their money.
Those were authorized.
A 2-year lease on a brand new Ford Expedition. According to a federal indictment unsealed in the Eastern District of Michigan, every payment on that lease came directly out of money embezzled from the estate of an incapacitated court ward, a woman who, by definition, could not see, control, or contest what was being done with her assets. That single lease, a named lessee, a defined monthly draw, a vehicle parked at a specific Detroit address, would become the centerpiece of a federal indictment naming 4 defendants. One of them was a sitting judge of Detroit's 36th District Court. And federal prosecutors allege the operation behind that lease had been running quietly through the Wayne County probate system since 2016. Before we go any further, I have to tell you up front, this case is pretrial. Every allegation you are about to hear comes from a federal indictment returned in the Eastern District of Michigan, and the judge at the center of it is presumed innocent unless and until a jury says otherwise. That is exactly how the system is supposed to work. But the architecture the FBI describes is something you need to see, because if even half of it is true, it is one of the quietest, most surgical betrayals of public trust I have ever covered on this channel. Drop a comment and tell me, do you trust the system that's supposed to protect people who can't protect themselves? And if you're new here, hit subscribe. We cover the cases the local news lets disappear after the press conference. Andrea Bradley-Baskin was born in Detroit in 1979. She grew up in a household where the law was not an abstraction. It was the topic of dinner. Her father, Avery Bradley, was a working Detroit attorney with a practice rooted in the quietest corner of the courthouse. Wills, estates, conservatorships, guardianships. The kind of cases where the person whose life is being decided is, more often than not in the room. Neighbors who knew the family described Avery Bradley as a man who carried the same brown leather briefcase for 2 decades and who knew, by first name, the clerks at the Wayne County probate court counter. Andrea was his oldest child. She rode along to the courthouse on school holidays. She sat on the wooden benches in the back of probate hearings while her father argued accountings and inventory reports. By the time she was 14, she could read a probate docket, line items, case numbers, fiduciary appointments, the way other kids her age read the back of a cereal box. She attended Renaissance High School on the city's west side and graduated in 1997 in the top quarter of her class. Teachers later described her in evaluations as, quote, sharp, composed, comfortable with adults, already in the habit of arguing her position. She enrolled at the University of Michigan in Ann Arbor that fall, declared a political science major, and graduated in 2001 with a 3. 6 grade point average, and the kind of clean undergraduate transcript that admissions officers reward. She was admitted to the University of Detroit Mercy School of Law on a partial scholarship and started in the fall of 2002. Classmates remembered her as the student in the second row who never missed a reading and who, in her second year, took both probate practice and trusts and estates back to back. Electives the rest of the class was actively avoiding because the material was considered dry. She graduated in 2005 and was admitted to the State Bar of Michigan that same year. She did not look for a job at one of the downtown towers. She did not interview at the big litigation shops. She walked into her father's office on 8 Mile Road, sat down across from him, and said she was joining the firm. By the end of that month, the shingle on the door read, Bradley and Bradley, attorneys at law. She was 26 years old. The firm's bread and butter was Wayne County Probate Court. They represented fiduciaries, guardians, conservators, professional fiduciary agencies, appointed to manage the affairs of people the court had determined could no longer manage their own, wards. The legal term is wards. It is a clean 3-letter word that describes a person whose entire financial life has been handed, by court order, to someone they may not have chosen and may not even know. Around 2009, the firm began representing a fiduciary company called Guardian and Associates, owned and operated by a Detroit woman named Nancy Williams. Williams's company specialized in being appointed by the Wayne County Probate Court to manage the affairs of incapacitated adults, people with advanced dementia, people with severe brain injuries, elderly people with no surviving family, and her caseload grew. Over the years that followed, Guardian and Associates would be appointed in more than 1,000 individual ward cases. In that same orbit was a man named Dwight Rashad. Rashad, then in his mid-50s, ran a series of group homes and adult residential facilities across the Detroit metropolitan area. The homes were the kind of places that show up on a Wayne County fiduciary's resource list. Small residential properties, 6 to 10 beds each, the bottom rung of the elder care ladder, the kind of place a ward gets placed when there is no family willing to take them in. By the early 2010s, Andrea Bradley-Baskin was a known face at the Wayne County Probate Court counter. She filed annual accountings. She filed inventories. She appeared at fiduciary review hearings. The clerks knew her by name. She was raising a family at the same time. She had married. She had taken the hyphenated last name. And friends from that period described her as the kind of working mother who answered email at 6 in the morning and was still at the office at 7 at night. In 2016, according to the federal indictment, the conduct at the center of this case began. The arrangement, prosecutors would later allege, was quiet, contained, and structurally elegant. Williams's fiduciary agency was appointed by the probate court over wards. The Bradley and Bradley law firm represented the fiduciary agency. Rashad's group homes housed, or in some cases, were billed as if they housed, those same wards. And the lawyer signing off on the paperwork from the fiduciary's side was the daughter of the firm's senior partner. None of that, on paper, was illegal. Lawyers represent fiduciaries every day in every probate court in the country. The arrangement only becomes a crime, according to the indictment, when the people inside it stop acting on behalf of the wards and start acting on behalf of themselves. In 2023, Andrea Bradley-Baskin left private practice. She was sworn in as a judge of the 36th District Court of Detroit. In November of 2024, she stood for election to a full 6-year term and won. The term, on paper, ran to early 2031. By every public measure, she had arrived. She was 45 years old, the daughter of a Detroit attorney, now a sitting judge in the city where she had grown up. The federal indictment alleges that the conduct at the Wayne County Probate Court, the quiet 4-way arrangement, the routing of ward funds outward, did not stop when she took the bench. It continued. To understand what federal prosecutors say happened in this case, you have to understand the role of a guardian and a conservator under Michigan law. Because there is no fiduciary position in American civil law that is more unilateral than this one. A guardian, in Michigan, is a person appointed by the probate court to make decisions about the person of an incapacitated adult, where they live, what medical care they receive, who can visit them. A conservator is appointed to manage their property, their bank accounts, their Social Security checks, their pension distributions, their settlement money, their houses, their cars, their everything. The ward, by legal definition, lacks the capacity to manage these things themselves. That is the entire predicate of the appointment. A person with full capacity does not get a guardian. So, the ward, in almost every case, cannot meaningfully supervise the fiduciary. They cannot read their own bank statements. They cannot follow a wire transfer through a series of accounts. They cannot show up at the courthouse and ask why a payment was made. The probate court is supposed to be the backstop. Every fiduciary is required to file annual accountings, a line-by-line listing of every dollar that came in and every dollar that went out of the ward's estate during the prior year. The court is supposed to review those accountings. In practice, in a high-volume urban probate system, the review is largely a paperwork audit unless someone raises a complaint. And the only people in a position to raise complaints are family members, social workers, or, occasionally, a fellow attorney who notices something off in a case file. Guardian and associates, according to court records, had been appointed in more than 1,000 individual ward cases over the years. One fiduciary agency. 1,000 people whose entire financial existence ran through its accounts. The charge in the indictment is that every safeguard in that ecosystem, the agency, the lawyers who represented the agency, the group homes that housed the wards, and, eventually, one of the lawyers seated on the bench down the hall, was held by people who were working together. The phrase the U.S. Attorney's Office used in its statement was, quote, preying on the needy, protected by the court. The phrase the FBI special agent in charge used was, quote, looting bank accounts, exploiting legal authority, and profiting off those who relied on them for care and protection. That is the framing federal prosecutors brought to the indictment. The 36th District Court itself, within hours of the indictment being unsealed, administratively removed Bradley-Baskin from her docket. The State Court Administrative Office signed off on the removal the same day. The institutional message was clear. The court could not have a sitting judge under federal indictment for stealing from court wards continuing to call cases from a bench in the same building. The presumption of innocence remained. The docket did not. The mechanism described in the federal indictment is, on paper, almost mundane. There is no dramatic break-in. There is no falsified will. There is no body. There is instead a paper trail. According to prosecutors, the four-party arrangement worked like this. The Wayne County Probate Court would appoint Williams's guardian and associates as fiduciary for an incapacitated ward. The ward, by definition, was a person who could not meaningfully participate in their own affairs. The fiduciary agency would then engage the Bradley and Bradley law firm, the father and daughter operation, to handle the legal representation in probate court. Bradley-Baskin and her father, as the lawyers, would file the accountings, the inventories, the petitions for fees, the requests for court approval of payments. The fiduciary agency would then arrange for the ward to be housed at one of Dwight Rashad's group homes. That last step is where the indictment alleges the first crack opens. Federal prosecutors charged that Rashad's group homes were paid rent for wards who did not actually live at one of his homes. The fiduciary agency, with the law firm filing the paperwork, allegedly authorized rental payments out of the ward's funds to a group home where the ward was not present. Where the actual ward was, in a different placement with a family member, in a hospital, deceased, varied case by case. What did not vary, according to prosecutors, was the rent check. The second mechanism, according to prosecutors, was the direct rerouting of settlement funds and estate funds. When a ward had a personal injury settlement, or a wrongful death settlement, or an inheritance, those funds, by law, flow into the conservatorship account. Every dollar in, every dollar out, documented. In one alleged instance laid out in the indictment, prosecutors say the defendants took nearly $203,000 from a ward's legal settlement. None of that money, prosecutors allege, was used for the benefit of the ward whose claim had produced the settlement in the first place. $203,000 from a single ward, channeled outward. The specific personal expenditures named in the indictment against Bradley-Baskin are what moved this case from a quiet probate scheme into something else. Federal prosecutors allege that approximately $70,000 in a ward's funds was used by Bradley-Baskin to purchase an ownership stake in a local Detroit bar. Not a one-time small distribution, a capital investment. The kind of transaction that creates corporate paperwork, an ownership interest, a name on a partnership agreement. $70,000 of a person who could not consent allegedly turned into a documented ownership stake in a business held by the lawyer, representing the fiduciary appointed to manage that person's affairs. The second named expenditure, and the one prosecutors will most likely build the case around, is the Ford expedition. Federal prosecutors allege that funds embezzled from the estate of a ward were used to pay the 2-year lease on a brand new Ford Expedition that Bradley-Baskin drove personally. Not a vehicle for the firm, not a vehicle for the fiduciary agency, a vehicle for her personal use, paid for, allegedly, out of the assets of an incapacitated person. In total, prosecutors say Bradley-Baskin personally received close to $100,000 of the embezzled funds. Across all 4 defendants, the total alleged take is approximately $273,000. Some reporting puts the figure closer to $300,000. Against federal indictments out of the Eastern District of Michigan, that is a small dollar figure. The district routinely announces fraud cases in the multiple millions. The harm in this case is not in the headline number. The harm is in the architecture. One fiduciary agency appointed to more than 1,000 wards. One law firm representing the agency. One group home operator, housing, or billed as housing, the wards. And eventually, one of the lawyers from the firm, sitting on a judicial bench in the same building where the probate cases were filed. Every check on the system was, allegedly, held by the same 4 people. The conduct, as charged, began in 2016. It continued for years. The indictment does not allege a single bad month or a single bad year. It alleges a pattern. A pattern is the difference between a mistake and a scheme. A pattern is what federal prosecutors charge. What changed, in the end, was attention. Federal prosecutors did not announce, in the unsealed indictment, the precise origin point of the investigation. There is no named whistleblower in the public charging documents. There is no single complaining family member identified by name. What there is, instead, is the visible work of the FBI Detroit Field Office and the U.S. Attorney's Office for the Eastern District of Michigan over the months leading up to January 30th, 2026. In the kind of investigation federal agents run when they are looking at a fiduciary scheme, what triggers the work is rarely a single dramatic event. It is, more often, an accumulation, a probate accounting that does not match a bank statement, a rental payment to a group home for a person who has been dead for 8 months, a wire transfer from a conservatorship account to a partnership filing that, on its face, has nothing to do with the ward, a complaint from a family member who finally got a copy of an inventory report and asked, "Where did the settlement money go?" Federal investigators followed the paper. That is what a fiduciary investigation is. A fiduciary, by law, has to leave paper. The accounting goes to the court. The rent check has a payee. The bar ownership stake produces a partnership document. The vehicle lease has a lessee, a monthly draw, and a registration. For any one of those documents, there is a defensible explanation. For all of them at once, in the configuration the indictment lays out, there is, in the FBI's view, a pattern. The State Court Administrative Office became aware of the federal investigation in advance of the unsealing. So did Chief Judge William McConaughey of the 36th District Court, both prepared for the morning of January 30th, 2026. By the time the indictment was returned by a federal grand jury and the U.S. Attorney's Office announced the charges, there was a contingency plan in place. The administrative removal from the docket was ready to file. The press statement was drafted. The state judicial system was bracing for the institutional fact of a sitting judge being indicted by federal prosecutors for stealing from court wards. What the broader public did not know until the morning of the unsealing was that the investigation had reached Bradley-Baskin personally. According to the indictment, at some point during the federal investigation, an FBI agent interviewed her. During that interview, prosecutors allege she made a false statement. That single false statement became its own separate count in the indictment, distinct from the wire fraud conspiracy, distinct from the money laundering, distinct from the underlying scheme. A standalone federal charge of making a false statement to a federal law enforcement agent. It is the count, in federal practice, that tends to indicate the investigators had already developed the underlying evidence before the interview. They were not asking the question to learn the answer. They were asking the question to see what she would say. The morning of January 30, 2026, all 4 defendants, Nancy Williams, Avery Bradley, Dwight Rashad, and Andrea Bradley-Baskin, were brought into the federal courthouse in downtown Detroit for arraignment. The federal indictment itself is the most complete public picture of the alleged conduct, and the structure of the charges is what tells the story. All 4 defendants are charged with conspiracy to commit wire fraud. Wire fraud is the federal workhorse statute in cases like this. It does not require a forged document or a stolen physical object. It requires a scheme to defraud and the use of an interstate wire, a bank transfer, an email, a phone call, a credit card swipe, in furtherance of that scheme. Conservatorship funds, by the nature of how modern banking works, move by wire. Every authorized payment is a wire. Every alleged unauthorized payment is, prosecutors argue, a wire in furtherance of the scheme. We're heading into the federal courtroom now. Before we do, if you've made it this far, you already understand why this case is different from the usual fraud headline. It isn't the dollar figure, it's the architecture. If you want to see how the system handles a sitting judge under federal indictment, subscribe and stay with me. We break down every detail. Avery Bradley, Bradley-Baskin's father, the senior partner of the law firm, is charged with an additional standalone count of wire fraud. Bradley, Bradley-Baskin, and Rashad are each charged with multiple counts of money laundering. Money laundering, in federal practice, is the charge prosecutors bring when funds traceable to an underlying crime are moved through accounts or transactions designed to disguise the source. the $70,000 bar ownership stake, the Ford Expedition lease, the rent payments to group homes for wards who allegedly did not live there. Each of those is, in the prosecutorial theory of the case, a money laundering transaction. The wire fraud conspiracy creates the dirty money. The money laundering counts cover what the defendants allegedly did with it. The Ford Expedition lease is, according to prosecutors, the cleanest single piece of evidence in the case. The reason is structural. Most embezzlement cases require federal investigators to trace dollars through a series of accounts, out of a conservatorship account, into a personal account, out of a personal account, into a corporate account, and so on. Each step in the chain produces an evidentiary hurdle. A defense lawyer can argue that the dollar in the personal account was not the same dollar that came out of the ward's estate. A vehicle lease eliminates that argument. The lessee is named. The monthly draw is fixed. The payments on the indictment's theory came directly from a ward's funds. The vehicle is parked at a specific address. The driver is the named lessee. There is no commingling argument to make. The same logic, prosecutors say, runs through the $70,000 bar ownership stake. A wire transfer leaves an account. An ownership document gets filed. The named owner is the same person who, allegedly, drew the funds out of the ward's estate to pay for the stake. That is the configuration prosecutors say the case has, repeatedly. A line item, a named payee, a paper trail that ends in a defined asset held by a defined person. The FBI Detroit field office, by the time the indictment was returned, had compiled records spanning years. Probate court filings, conservatorship accountings, group home billing records, bank records, partnership and corporate filings for the bar, vehicle lease documents, tax filings, communications. The volume of paper in a fiduciary case is enormous, and a federal grand jury does not return a multi-count indictment without seeing it. The defendants are presumed innocent. Each of them will have the opportunity to challenge every piece of that paper. That is what the trial process is for. The public confrontation in this case is not a doorstep arrest. It is the arraignment. On the morning of January 30th, 2026, in the federal courthouse in downtown Detroit, U.S. Magistrate Judge David Grand called the case. The defendants were brought in. The courtroom gallery was full. Local reporters had been alerted. A sitting state court judge being arraigned in federal court is not a routine docket event in any district. The lead assistant U.S. attorney walked through the charges in open court. Conspiracy to commit wire fraud against all four defendants. An additional count of wire fraud against Avery Bradley. Multiple counts of money laundering against Bradley, Bradley-Baskin, and Rashad. One count of making a false statement to a federal law enforcement agent against Bradley-Baskin alone. The magistrate judge asked Bradley-Baskin whether she understood the charges. She answered yes. The magistrate judge asked whether she had been advised of her right to counsel and her right to remain silent. She answered yes. The magistrate judge asked how she wished to plead. Not guilty, Your Honor. The magistrate judge set conditions of release. Surrender of passport. Travel restricted to the Eastern District of Michigan. No contact with the other named defendants outside the presence of counsel. Bond set on standard conditions for a non-violent federal indictment. The case was set for a status conference before the assigned district judge. Outside the courtroom, in the hallway of the federal courthouse, Bradley-Baskin did not speak to reporters. Her counsel issued a brief statement reiterating her presumption of innocence and her intention to defend the case at trial. She left the courthouse through a side corridor. By the time she reached the parking structure, the state court administrative office had already issued its order. She was, effective that afternoon, removed from her docket at the 36th District Court of Detroit. This is the part of the story that, ordinarily, would be a sentencing. In this case, it cannot be. The case is pre-trial. No jury has been seated. No witness has testified under oath in front of a fact finder. No verdict has been entered. The reckoning, for now, is institutional, not penal. U.S. Attorney Jerome Gorgon stood at the podium at the press conference held the morning of the unsealing. He spoke in the careful, plain language federal prosecutors use when they are announcing a politically sensitive case. "We respect the authority that covers a black robe," he said. This state judge and her cronies allegedly abused that high honor for personal gain by preying on the needy, protected by the court. This would be a grievous abuse of our public trust. Jennifer Runyon, the special agent in charge of the FBI Detroit field office, followed him. "Regardless of a person's position in society, no one is above the law," she said. "These 4 defendants allegedly conspired to steal from some of our most vulnerable citizens, looting bank accounts, exploiting legal authority, and profiting off those who relied on them for care and protection." Chief Judge William McConaughey of the 36th District Court issued a separate statement that afternoon. He confirmed that Bradley-Baskin had been administratively removed from her docket following the federal indictment, that the action had been approved by the state court administrative office, and that, in his words, she maintains the presumption of innocence and the right to due process. The careful framing, institutional response on one side of the sentence, constitutional protection on the other, is what a chief judge says when the bench itself is under public examination. The charges Bradley-Baskin now faces, taken together, carry significant federal exposure. Conspiracy to commit wire fraud under federal sentencing law can produce decades of potential prison time depending on loss calculations and aggravating factors. Each money laundering count carries its own statutory maximum. Making a false statement to a federal agent, the single, freestanding count against her alone, carries a maximum of 5 years on its own. None of those numbers will mean anything until and unless a conviction is entered. The presumption of innocence is the operative legal status of every defendant in this case. The federal sentencing guidelines are a future problem. What is happening now, in the months between the arraignment and trial, is the slow grinding work of a federal white-collar prosecution. Discovery exchanges, defense motions, likely motions to sever defendants, likely motions in limine over what fiduciary records can come in, likely fights over the false statement count and what exactly was asked, what exactly was answered, and how the agent's report was prepared. While that grinds forward, the wards remain. Federal prosecutors did not name them in the public indictment. They are identified in the charging document by initials and case references. Some of them are still living, still incapacitated, still dependent on a fiduciary structure that, for the duration of this case, will be under a microscope. Some of them have died. The ward whose settlement allegedly produced the nearly $203,000 diversion is not a public figure. Her name does not appear in the indictment. The Wayne County Probate Court has, in the months since the indictment, begun a broader review of cases handled through Guardian and Associates. The State Bar of Michigan has its own procedures for cases involving licensed attorneys facing federal charges. The Michigan Judicial Tenure Commission has the authority to pursue judicial misconduct proceedings independent of the criminal case. None of those processes will produce headlines on the same scale as the federal indictment. All of them will produce consequences. The 36th District Court of Detroit handles on any given week thousands of cases: traffic, landlord-tenant, small claims, misdemeanors, arraignments. It is one of the busiest district courts in the state of Michigan. The docket Bradley-Baskin was elected in 2024 to manage for a 6-year term running to 2031. That docket is now being absorbed case by case by her colleagues. Her chambers are quiet. Her name has been removed from the assignment rotation. The presumption of innocence is real. The institutional damage is also real. Both of those things are true at once, and the system has to hold both of them at the same time, because that is what the system is. This case was quiet, but this case on the right-hand side is even more outrageous. Click it now.